Good morning, everyone. Virgo Triad here. It is June 29th, 2018. We have zipped through the month of June, and happy Friday to everyone. Okay, so I had a few people that emailed me with a very specific question with regards to copywriting your own name, and I thought that was a very interesting subject. So let me go over that with you briefly so that you understand that there are things that you can do with your name. However, copywriting actually isn't one. I'm going to link the articles that I'm using to the description box for you to read for yourself. You can verify these things through the U.S. Patent and Trademark Office. First of all, let's take a look at this 5 things that cannot be copyrighted. And you will see that actually number 1 on the list right here of the copyright law states that titles and names, copyright protection does not extend to those things. It doesn't extend to titles, names, slogans, or short phrases. The Copyright Office has made that very clear. You cannot copyright your own name, the title of your post, or any short phrase that you use to identify a work. The reason is that copyright is designed to protect works of creative authorship. It is not to protect how that work is identified in the marketplace. The same goes for people and places. Furthermore, such short phrases rarely meet the requisite level of creativity to be considered for copyright protection. All right, so just so that you guys are aware, your question was, can you copyright your own name? No, you absolutely cannot copyright your own name. If someone is telling you to file a copyright with your own name, then what you're going to do is you're going to end up spending a filing fee that is going to go nowhere. Now, there are places within the United States that you can file for just about anything, and they will accept the filing, but when you go to actually attempt to try to use that documentation in a court setting, for example, let's just say that someone uses your name and you do not want them to use your name within a video or within a written article or a blog, and you feel because you have filed you filed a copyright on your name that gives you license to go and sue them for every instance that they file. It is absolutely not true. You will get to court and you will fail. The copyright laws do not provide you with the protection to copyright your own name. Now, what can you do in order to protect your name? In certain instances, you can do what's called a trademark. And I'm going to take you over to a page that will show you that trademarking your name is a possibility. It's only a slim possibility, though, and it's also extremely expensive and time-consuming. Jean Murray wrote an article back in September of 2017 in the small business column of the Balances, mb.com, and in that particular article, Jean goes in to explain when it would be a good idea to trademark your name and the expense that goes into it, along with the consumed time that it takes in order to do this with the U.S. Patent and Trademark Office, the USPTO. It basically is going to take about the same amount of time to do this due to all of the research that has to be done by the trademark office as it does to get a U.S. patent. And here is the reason why. Registering your name is one thing, okay? When you go in and you actually go to a Secretary of State, you file a fictitious business name, and that business name you own for a certain amount of years, and you have it registered under the state. It's very inexpensive, very quick. All you have to do is look up through the search engine to make sure that that name hasn't been used by another business within the same county, and there you have it. But trademarking your name is completely different. You have to go through the patent office in order to do that. Qualifications for trademarking a name. For example, a lot of people that trademark their names are actors, authors, fashion designers, sport figures, celebrities, people of that type. So, for example, it uses an example here of Sarah Palin, widely known name. She has a service mark, which is similar to a trademark. And the way that that happened with Sarah Palin is because she is a very, very well-known personality. So if you are not a well-known personality in commerce, if you are not somebody that is a Michael Kors or somebody who is a Louis Vuitton, you are not going to have a real easy time getting approved for a trademark through the U.S. Patent and Trademark Office. A trademark is a piece of intellectual property that allows you to brand something so that no one else can copy it or use it. It distinguishes your company and its products from everyone else. But many people confuse a trademark with a copyright. Copyright works are simply for things like books, movies, and videos. They protect property that so that someone can't take your property and use it elsewhere, whereas a trademark specifically pertains to a name. Now, like I said, the qualifications for a name to be trademarked are very, very stringent. It's also extremely expensive and time-consuming in order to do. So if you're going to think about trademarking your name, then you better have those things in line, or they're not even going to bother looking at it. You're going to pay filing fees, and they're going to end up rejecting it because a trademark is a piece of intellectual property, and that is something that they take very, very seriously. When deciding whether or not to allow you to essentially trademark your name. Just having a very popular YouTube channel or having being a personality on Blog Talk Radio does not give you free license to think that you should be able to trademark your name if your name is not extremely large in the area of commerce, okay? They're looking at protecting people like celebrities, actors, sports figures, and people that are sponsored frequently, fashion designers. So they're looking at, overall how well your name is used. If we're talking about using someone like Dustin Hoffman, obviously everybody recognizes who Dustin Hoffman is. So something that you have to think about. Now, you can go ahead and take a look at these articles. I'm going to link them both in the description, but I want to inform you all that in the event that you're being told, as I said, that you can copyright your name, please think twice. You're wasting valuable filing funds simply because it is not a possibility. If you're in doubt of what I am telling you, pick up the phone and call a copyright attorney, and they will tell you absolutely not. You cannot. It is the #1 rule in the copyright offices of every single state. You absolutely cannot copyright your own name for the purpose of keeping people from using it or stating that name in articles and blogs, so on and so forth. If that were the case, nobody would be able to write about Michael Kors' new line coming out. All right, everyone, I hope this helps to answer your question, and I hope everyone has a wonderful weekend. Take care.